Hello, this is Mike Crowley with the Introduction to United States Government course online. Welcome. In today's lecture, we cover the judiciary, also called the courts in your textbook. In today's lecture, we have an in-class recording, again allowing you, the online student, the opportunity to hear your classmates ask questions and me attempt to answer them. We're going to dive right in, so grab your cup of coffee, your notebook, and let's get cracking.
What we're doing tonight, then, is judiciary. So this is the last lecture out of the book. And so some of the terms that you should be familiar with from doing the reading would be amicus curiae brief, an appellate court, the idea of case law, the idea of common law, judicial restraint, jurisdiction, limited jurisdiction, the idea of litigation, the idea of a trial court. All these should sound somewhat familiar, and I'm sure you're going to do great on that. So let me start with the seminar question. Right? Does the prerogative of judicial review held by the Supreme Court complement or detract from the ideal of representative democracy and of pluralism? So we go on then with the first introduction, the idea that the federal judiciary in particular is a very powerful institution. Only in the United States, it's argued, do the judges, the judiciary, play so large a role in the actual policy-making process. Usually the policy-making process is fairly well limited to the political branches. And in the United States, then the political branches would be the Congress and the presidency, leaving the judiciary as the non-political branch. So I would argue, though, that the policy-making potential of the judiciary is much larger than the reality. So even though they have a large role in the policy-making process, their potential role, how far that role can go, is actually enormous. It's much bigger than you might expect. Woodrow Wilson once described the Supreme Court as a constitutional convention in continuous session. So we're going to be talking about the role of the court, and the role of the justices in particular, in interpreting the Constitution. And so here we are, as you would suggest, right? And we're looking at the Constitution with
present-day
eyes. So some of the issues that we're dealing with today, right? Same-sex marriage, medical marijuana, euthanasia, some amount of states' rights. The original intent, the founders' intent, wouldn't have even conceived of. I mean, same-sex marriage in 1788, not even conceivable. And yet here we have the federal judiciary interpreting the founders' intent of the Constitution with an eye to these contemporaneous policy issues, right? And so what they're doing then is they're updating the Constitution. With every interpretation of constitutional intent or founders' intent, they're updating the Constitution to mean ... For example, how many people in here believe that the Constitution invokes a right to privacy, that there's a right to privacy listed in the Constitution as your constitutional right? Okay. And yet, it's nowhere in the Constitution, right? It's a conflation of individual rights as expressed, especially in the Bill of Rights. But the word privacy or the right to privacy is nowhere to be found. It's the court's interpretation of the Constitution to mean that we have a right to privacy. So the prohibition against search and seizure, quartering of soldiers, those are foundational in determining privacy. So that's what we're talking about, right? To be protected from unwarranted search and seizure is talking about your privacy, the privacy of your home and your effects. Right? So privacy exists without saying so. It took the courts to interpret the Constitution to mean, oh, that's right, and it, even though it doesn't say it, it is in there. It is, as we're ever want to do, we go to the Federalist Papers. And so specifically, this is Federalist number 78, and this is by Hamilton, writing in 1788, and again, this is to the people of New York. The Federalist number 78, titled The Judiciary Department, by Alexander Hamilton, June 1788. We proceed now to an examination of the Judiciary Department of the proposed government. In unfolding the defects of the existing Confederation, the utility and necessity of a federal judicature have been clearly pointed out. It is the less necessary to recapitulate the considerations there urged, as the propriety of the institution in the abstract is not disputed. The only questions which have been raised being relative to the manner of constituting it and to its extent. To these points, therefore, our observation shall be confined. The manner of constituting it seems to embrace these several objects. First, the mode of appointing the judges. Second, the tenure by which they hold their offices. Third, the partition of the judiciary authority between different courts and their relation to each other. First, as to the mode of applying the judges, this is the same with that of appointing the officers of the Union in general, and have been so fully discussed in the last two numbers that nothing can be said here which would not be useless repetition. Second, as to the tenure by which the judges are to hold their places, this chiefly concerns their duration in office, the provisions for their support, the precautions for their responsibility. According to the plan of the Constitution, all judges who may be appointed to the United States are to hold their offices during good behavior, which is conformable to the most approved of the state constitutions, and among the rest to that of this state.
And this is an important distinction. While political officers, those who are elected for impeachment, are held to high crimes and misdemeanors, justices, judges, are held to a lower bar, which is good behavior. This is a constitutional mandate.
Its propriety, having been drawn into question by the adversaries of that plan, is no light symptom of the rage for objection, which disorders their imaginations and judgments. The standard of good behavior for the continuance in office of the judicial magistracy is certainly one of the most valuable of the modern improvements in the practice of government. In a monarchy, it is an excellent barrier to the despotism of the prince. In a republic, it is no less an excellent barrier to the encroachments and oppressions of the representative body. It is the best expedient which can be devised in any government to secure a steady, upright, and impartial administration of the laws. Whoever attentively considers the different departments of power must perceive that in a government in which they are separated from each other, the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, because it will be least in a capacity to annoy or injure them. The executive not only dispenses honor, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either in the strength or the wealth of the society, and can take no active resolution whatever. It may be truly said to have neither force nor will, but merely judgment, and must ultimately depend on the aid of the executive arm for the efficacy of its judgments. This simple view of the matter suggests several important consequences. It proves incontestably that the judiciary is beyond comparison the weakest of the three departments of power, that it can never attack with success either of the other two, that all possible care is requisite to enable it to defend itself against their attacks. It equally proves that though individual oppression may now and then proceed from the courts of justice, the general liberty of the people can never be endangered from that quarter. I mean, so long as the judiciary remains truly distinct from both legislature and the executive, for I agree that there is no liberty if the power of judging be not separated from the legislative and executive powers. And it proves in the last place that as liberty can have nothing to fear from the judiciary alone, but would have everything to fear from its union with either of the other departments, that as all the effects of such a union must ensue from a dependence of the former on the latter, notwithstanding a nominal and apparent separation, that as, from the natural feebleness of the judiciary, it is in continual jeopardy of being overpowered, awed, and influenced by its coordinate branches, and that as nothing can contribute so much to its firmness and independence as permanency in office, this quality may therefore be justly regarded as an indispensable ingredient in its constitution, and, in a great measure, as the citadel of public justice and the public security. The complete independence of the courts of justice is particularly essential in a limited constitution, By a limited constitution, I understand one which contains certain specified exceptions to the legislative authority, such, for instance, as that it shall pass no bills of attainder, no ex post facto laws, and the like. Limitations of this kind can be preserved in practice no other way than through the medium of the courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. Without this, all the reservations of particular rights and privileges would amount to nothing. Some perplexity respecting the rights of the courts to pronounce legislative acts void, because contrary to the Constitution, has arisen from an imagination that the doctrine would imply a superiority of the judiciary to the legislative power. It is urged that the authority which can declare the acts of another void must necessarily be superior to the one whose acts may be declared void. As this doctrine is of great importance in all the American constitutions, a brief discussion on the ground on which it rests cannot be unacceptable. There is no position which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution, can be valid. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. If it be said that the legislative body are themselves the constitutional judges of their own powers, and that the construction they put upon them is conclusive upon the other departments, it may be answered that this cannot be the natural presumption, where it is not to be collected from any particular provisions in the Constitution. It is not otherwise to be supposed that the Constitution could intend to enable the representatives of the people to substitute their will to that of their constituents. It is far more rational to suppose that the courts were designed to be an intermediate body between the people and their legislature, in order, among other things, to keep the latter within the limits assigned to their authority. The interpretation of the laws is the proper and particular province of the courts. A constitution is, in fact, and must be regarded by the judges as fundamental law. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance between the two, that which has the superior obligation and validity ought, of course, to be preferred, or, in other words, the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents. Nor does this conclusion by any means suppose the superiority of the judicial to the legislative power. It only supposes that the power of the people is superior to both, that where the will of the legislature, declared in its statutes, stands in opposition to that of the people declared in the Constitution, the judges ought to be governed by the latter rather than the former. They ought to regulate their decisions by the fundamental laws rather than by those which are not fundamental. The exercise of judicial discretion in determining between two contradictory laws is exemplified in a familiar instance. It not uncommonly happens that there are two statutes existing at one time, clashing in whole or in part with one another, and neither of them containing any repealing clause or expression. In such a case, it is the province of the courts to liquidate and fix their meaning and operation. So far as they can, by any fair construction, be reconciled to each other, reason and law conspire to dictate that this should be done, where this is impracticable. It becomes a matter of necessity to give effect to one in exclusion of the other. The rule which is obtained in the courts for determining their relative validity is that the last in order of time shall be preferred to the first. But this is a mere rule of construction, not derived from any positive law, but from the nature and reason of the thing. It is a rule not enjoined upon the courts by legislative provision, but adopted by themselves, as consonant to truth and propriety for the direction of their conduct as interpreters of law. They thought it reasonable that between the interfering acts of an equal authority, that which was the last indication of its will should have the preference. But in regard to the interfering acts of a superior and subordinate authority, of an original and derivative power, the nature and reason of the thing indicate that converse of the rule as proper to be followed. They teach us that the prior act of a superior ought to be preferred to the subsequent act of an inferior and subordinate authority, and that accordingly, when a particular statute contravenes the Constitution, it will be the duty of judicial tribunals to adhere to the latter and disregard the former. It can be of no weight to say that the courts, on the pretense of repugnancy, may substitute their own pleasure to the constitutional intentions of the legislature. This might well happen in the case of two contradictory statutes, or it might as well happen in every adjudication upon any single statute. The courts must declare the sense of the law, and if they should be disposed to exercise will instead of judgment, the consequence would equally be the substitution of their pleasure to that of the legislative body. The observation, if it prove anything, would prove that there ought to be no judges distinct from that body. If, then, the courts of justice are to be considered as the bulwarks of a limited constitution against legislative encroachments, this consideration will afford a strong arguments for the permanent tenure of judicial offices, since nothing will contribute so much as this to that independent spirit in the judges which must be essential to the faithful performance of so arduous a duty. This independence of the judges is equally requisite to guard the Constitution and the rights of the individuals from the effects of those ill humors which the arts of designing men or the influence of particular conjunctures sometimes disseminate among the people themselves, and which, though they speedily give place to better information and more deliberate reflection, have a tendency in the meantime to occasion dangers, innovations in the government, and serious oppressions of the minor party in the community. Though I trust the friends of the proposed Constitution will never concur with its enemies in questioning the fundamental principle of republican government, which admits the right of the people to alter or abolish the established Constitution whenever they find it inconsistent with their happiness, yet it is not to be inferred from this principle that the representatives of the people, whenever a momentary inclination happens to lay hold of a majority of their constituents, incompatible with the provisions of the existing Constitution, would, on that account, be justifiable in violation of these provisions, or that the courts would be under a greater obligation to connive at infractions in this shape than when they had proceeded wholly from the cabals of the representative body. Until the people have, by some solemn and authoritative act, annulled or changed the established form, it is binding upon themselves collectively as well as individually, and no presumption or even knowledge of their sentiments can warrant their representatives in a departure from it prior to such an act. But it is easy to see that it would require an uncommon portion of fortitude in the judges to do their duty as faithful guardians of the Constitution, where legislative invasions of it had been instigated by the majority voice of the community. But it is not with a view to infractions of the Constitution only that the independence of judges may be an essential safeguard to the effects of occasional ill humors in the society. These sometimes extend no further than to the injury of the private rights of particular classes of citizens by unjust and partial laws. Here the firmness of the judicial magistracy is of vast importance in mitigating the severity and confining the operation of such laws. It not only serves to moderate the immediate mischiefs of those which may have been passed, but it operates as a check upon the legislative body in passing them, who, perceiving that obstacles to the success of iniquitous intention are to be expected from the scruples of the court, are in a manner compelled, by the very motives and the injustice they mediate, to qualify their attempts. This is a circumstance calculated to have more influence upon the character of our governments than but few may be aware of. The benefits of the integrity and moderation of the judiciary have already been felt in more states than one, and though they may have displeased those whose sinister expectations they may have disappointed, they must have commanded the esteem and applause of all the virtuous and disinterested. Considerate men of every description ought to prize whatever will tend to beget or fortify that temper in the courts, as no man can be sure that he may not tomorrow be the victim of a spirit of injustice, by which he may be a gainer today. And every man must now feel that the inevitable tendency of such spirit is to sap the foundations of public and private confidence, and to introduce in its stead universal distrust and distress. That inflexible and uniform adherence to the right of the Constitution and of individuals, which we perceive to be indispensable in the courts of justice, can certainly not be expected from judges who hold their office by a temporary commission. Periodical appointments, however regulated, or by whomever made, would in some way or another be fatal to their necessary independence. If the power of making them was committed either to the executive or legislature, there would be danger of an improper complaisance to the branch which possessed it. If to both, there would be an unwillingness to hazard the displeasure of the other. If to the people or to persons chosen by them for this special purpose, there would be too great a disposition to consult popularity, to justify reliance, that nothing would be consulted but the Constitution and the laws. There is yet a further and weightier reason for the permanency of judicial offices, which is deducible from the nature of the qualifications they require. It has been frequently remarked with great propriety that a voluminous code of laws is one of the inconveniences necessarily connected with the advantages of free government. To avoid an arbitrary discretion in the courts, it is indispensable that they should be bound down by strict rules and precedents, which serve to define and point out their duty in every particular case that comes before them, and will readily be conceived from the variety of controversies which grow out of the folly and wickedness of mankind, that the records of those precedents must unavoidably swell to a very considerable bulk, and must demand long and laborious study to acquire a competent knowledge of them. Hence it is, and there can be but few men in society who will have sufficient skill in the laws to qualify them for the stations of judges, and making the proper deductions from the ordinary depravity of human nature. The number must be still smaller of those who unite the requisite integrity with the requisite knowledge. These considerations apprise us that the government can have no great option between fit character and that a temporary duration in office, which would naturally discourage such characters from quitting a lucrative line of practice to accept a seat on the bench, would have a tendency to throw the administration of justice into hands less able and less qualified to conduct it with utility and dignity. In the present circumstances of this country, and in those in which it is likely to be for a long time to come, the disadvantages on this score would be greater than they may at first sight appear, but it must be confessed that they are far inferior to those which present themselves under the other aspects of the subject. And he concludes, upon the whole, there can be no room to doubt that the Convention acted wisely in copying from the models of those constitutions which have established good behavior as the tenure of the judicial offices in point of duration, and that so far from being blamable on this account, their plan would have been inexcusably defective if it had wanted this important feature of good government. The experience of Great Britain affords an illustrious comment on the excellence of the institution.
You'll have to forgive me for having read that all into this record, Federalist number 78, but my friends, there really is a method to my madness, believe it or not. What I'd like to ask you to do, if you don't mind, is in your mind, instead of thinking about the role of the legislature, think about the role of the executive, and whether you supported him or not. Again, as always, I am completely nonpartisan in this class. I do not show any political favoritism one way or the other. But replace the word legislature with the word executive, and go back and re-listen to that with an eye toward President Trump's 60-plus court cases subsequent to the election, i.e. the post-election lawsuits related to the 2020 United States presidential election. And think about the role of the judges, the multiple judges, and the pressure put upon them politically by the president's campaign. Now again, whether you supported him or not, I care not. That's not my gig. What I'm asking you to do is to look at the mechanics of government and the protections in the Constitution and re-listen now to Federalist 78 again with that in your mind. Please do that for me.
Now, we have to back up a second and think, what is the role of the court? I mean, really, from the 30,000-foot level, what is the role of the court? And I would argue the role of the court is to search for the truth. And I'll make this argument again and again, whether it's a civil case or a criminal case, what the judge is trying to do is to ascertain what is the truth. I have to go back to Thomas Aquinas in this definition of what is truth and go to his separation of law into four overarching areas, four overarching classifications of law in order for me to express to you this search for the truth in the Judiciary Department. So Thomas Aquinas, we remember, is a doctor of the church. In other words, he's a philosopher, a theological thinker. All right, so like having a PhD in theology or a doctor of theology. He's a doctor of the church. And he says that there are four different types of law: eternal law, divine law, natural law, and human law. And it's the first one and the last one that I'm after in particular. The first one is the eternal law. So this is my definition of truth. Thomas Aquinas says that we see a law above our minds, which is the truth. The law which is above our minds is the eternal law. Therefore, truth is the eternal law. So here's how. There is the truth, the capital T truth, gravity. We may not be able to determine what causes gravity, but we know that it exists. Therefore, gravity is true. The idea of gravity is true. No matter what it is, what causes it, whether we can understand it or not, whether we can conceive of it, we can label it, we can name it, we can quantify it, it still is true. Apart from our human understanding and our ability to comprehend the universe around us, there is a truth. It does exist. What I'm trying to say is that whether we can understand it or not, whether we can see it or not, the truth exists. So if in a civil case or in a criminal case, if you're chasing after the facts, you may not get absolutely correct. You may not hit it square on the head. What is the truth? The idea is to get as close to the truth as possible. Okay. So this overarching truth, this truth that exists whether we understand it or not, is what Thomas Aquinas is calling the eternal law, the truth, capital T truth. Next, we have divine law. And so, again, he's a doctor of the church, so it's not surprising that we find this in his differentiation, that he says that since man is ordained to an end of eternal happiness which is not proportionate to man's natural faculty, it was necessary that beside the natural law and the human law, man should be directed to his end by a law given by God. And so you're talking about theological law. So no matter what faith tradition you belong to or you're studying, you're going to find some element of divine truth, whether it's the Ten Commandments or the Golden Rule. The next part is the natural law. And so the natural law is to be able to differentiate, he says, although we have no written law, yet they have the natural law, whereby each one knows that is conscious of what is good and what is evil. Now, this is going to be relative. This is going to be subjective. And I'm going to make my example here. So is it true that we all human beings, no matter where we are on the planet, know what is good and what is bad? Or is that subjective? So I give you. Is kicking a dog good or bad? Right. Now, right, you would say that, in our culture, kicking a dog is considered bad. In other cultures, kicking a dog is either, It's a given. It's inconsequential. It doesn't matter. Whatever your culture tells you is what your relative experience or your subjective experience is going to be. Is it good or bad, then, to allow somebody to die a natural death? Is euthanasia or doctor-assisted suicide good or bad? Right, now, we're beginning to see, okay, in some cultures, it's fine. In some cultures, it's accepted. In some cultures, it's dignified. In some cultures, whether they're ethnic cultures, political cultures, religious cultures, it's anathema. To end a life before God takes that is totally evil. It's bad. It's to be avoided. So again, this idea of natural law, you would expect would be universal, but it's not. And so, each society, each different society that finds expression, takes the natural law and expresses its interpretation of it in human law. Here's how. So he says that human reason needs to proceed to the more particular determination of certain matters. These particular determinations devised by the human reason are called human laws, provided the other essential conditions of law be observed. So, in our culture in 2013, then, we have laws against animal cruelty. Right? In California in 2013, we have human law that says it's against the law, it's against our code, our social agreement to intentionally, cruelly mistreat an animal. In other cultures, you're going to find that this isn't the case. Right? There is less of an imperative to be cruelty-free. In some cultures, it's fine to provide doctor-assisted suicide, and that would be the human law. In some cultures, it's not. Now, you may think, Mike, you're talking about the difference between perhaps the Eastern and the Western, or the First World or the Third World. How about the difference between Oregon and California? So Oregon has a law allowing doctor-assisted suicide, and California doesn't. But then California has a law prohibiting the death penalty, or allowing the death penalty, and Oregon has no law allowing the death penalty. So what is right and what is wrong isn't just a matter of different cultures, completely different cultures. It's also very specific to a region, even within a political system, like the United States. So the determination then of human law is what we're after here, but all the while bearing in mind this idea of the search for the truth, going back to step one, that the human law is intended to seek the truth. What is true for us? So bear with me. So how did we come up with this idea that we can have capital punishment in California, but we can't have doctor-assisted suicide? We, the electorate, decided that through the proposition and the initiative process. We asked ourselves, should we allow capital punishment? We said yes. We asked ourselves, in my memory, should we allow euthanasia? The answer was no. And yet we had an initiative about the size of a cage that a chicken must be kept in, right? That we can't be cruel, even to the point of how small the cage may be, to a chicken. So we are determining then for ourselves what is right and what is wrong, sometimes to great expense for ourselves. State-supported education. Some states don't have a strong commitment, or as a strong commitment to state-supported education as California does. In some states, you're kind of on your own, right? Or there's not quite the opportunity to have higher education. It's not as available, it's not as supported. So again, what is right and what is wrong is both a negative freedom and a positive freedom. You can't do this, and we are going to band together so that you can do this. You follow? So again, it's the search for the truth. So in California, what do we believe? Now, bringing it down a step further, in Napa, what do you believe? What policies, then, are collected in Napa? I talk about K through 12 education, which is a local specific decision. Right now, there are national and state parameters, but truly, with the Napa School District, then, there are local policies where we come together as Napa and say what is right and what is wrong. How much money are we going to contribute to K through 12 education, for example? Okay, so the search for the truth, that's what we're after. Again, the truth, whether it as it exists, whether we realize it or not, whether we see it or not, and how that's affected, how that's manifested through the human law or our codification, our making into code, the natural law, what is right and what is wrong for us. So we know that the human law in the U.S. political experience has a hierarchy. There is a structure. There's first the U.S. Constitution. We're going to go through these individually. Secondly, there's statute and treaty, executive orders and agreements, and federal regulations. We talked about these last week, right? We have case law, common law, and equity. And I'm going to introduce you to the idea of stare decisis. And so the Constitution is the hierarchy. In the hierarchy, the Constitution is the supreme law of the land because it says it is. So we talked about Article 6 in the Constitution, the Supremacy Clause. It said, this is the supreme law of the land. We said that it has to be, right? We argued in Chapter 2 that the Constitution has to be the supreme law so that no other law, federal law, state law, no individual, no church, no governor, nobody can be above this law. Right? No state, no president, no other power is above the Constitution because the Constitution is the codification of the social contract. The Supremacy Doctrine, the Supremacy Clause, Article 6, establishes that. So in the hierarchy of U.S. law, the Constitution comes first, always. Then you have statutory laws. Article 1 of the Constitution says all legislative powers here and granted shall be vested in the Congress of the United States. So what that means is that the Congress is constitutionally authorized, legitimately authorized to make law. Right? Statute is just another code, just another word for law, to be made into law. And so statutes are laws passed by the federal or state legislatures by the authority granted them in the Constitution. So this is the second tier in the hierarchy of law. And it comes before executive orders and regulations and federal bureaucratic regulations. Why? The president doesn't have the power to make law. We covered this. The president's job is to execute the law. Right? He is the chief administrator to Congress and the chief executive insofar as the bureaucracy is concerned. But the ability to implement Congress's law is his constitutional mandate. So his authority is resting on the authority already given to Congress. So the president's job is to administer the laws of Congress, is resting on that statutory process of making law, of making legislation. So the president's executive orders have to come second to the legislation, to the statute. If his job is to implement that, then he is a secondary player in that. Which isn't to say that he's unpowerful, right, or that his authority is at all questioned. But if you're looking at the hierarchy of law, then it's Constitution, statute, and executive orders, and bureaucratic regulations. Then we have case law, or common law. So this is where it gets a little dicey, and you're going to have to work with me here and just kind of let me play with this for a minute. So case law, or common law, is a body of law made up of judicial precedents and opinions. And so you go into a lawyer's office, right, and you're going to see law books, right? You're going to see walls and walls of law books, these beautifully bound law books, right? They're code books. And what their job is then is to compile the decisions of justices from the beginning of the political system to present. So if you have originally a law that says you will not steal sheep, the judiciary's job, as we know, is to interpret law and to interpret legislative intent. So the legislative intent is to stop people from stealing sheep. And yet you have, let's say, Farmer A and Farmer B. Okay, and Farmer A's sheep gets out of its pen and goes over to Farmer B's pen, and Farmer B doesn't recognize that it's not a sheep. I mean, all sheep look pretty much alike, right? And so he feeds the sheep and he cares for the sheep, and it's a part of his flock, but then Farmer A comes down the pike and says, you know, that's really my sheep, and he takes Farmer B to court. And so the question is, you will not steal sheep. Right? That's the law. Did Farmer B steal the sheep? So a judge has to sit down and search for the truth. Right? Now, this is a silly example, but work with me. So the judge sits down and says, well, there are mitigating circumstances. The sheep got out of its pen, and it went over, and Farmer B cared for it and fed it. So he didn't steal it. It was unintentional. So there are mitigating factors to this. So the judge says, I'm going to find, for Farmer B that, he didn't do this on purpose. He had every good intent. He didn't steal the sheep, so no. Boom. He set precedent. He interpreted the law to mean that in this specific case, this is what the law means. This is what the intent of the legislature was meant to achieve. All right. A year later, you have Farmer C. Right? Now, Farmer B's sheep gets out and goes down to Farmer C's field. But now Farmer C hides the sheep in the back of the field so that Farmer B wouldn't see it. Right? And so Farmer B sues Farmer C. They go back to the same judge. The judge is bound now to allow for the precedent, to include in his deliberation the precedent that was set before. So that precedent said that the interpretation of that law meant that Farmer A and Farmer B's, Farmer B didn't steal Farmer A's sheep. And so what parameters are like that in this case? Right? Well, the same thing, the sheep got out, but this case is just a little bit different because Farmer C actively hid the sheep from Farmer B. Something Farmer B didn't do. He set precedent. It's silly. Now, think about all the laws that we have and all the court cases that we have. And each case is going to, in some way, set some kind of precedent, some kind of new interpretation. So, are there any wannabe lawyers in here? Okay, so here's your job. Legal research. Your job is to go out there and find as many court cases as possible to bolster your argument. And so in this case, it looks a lot like this case, this case, this case, this case. But the legal team on the other side, you can imagine strategically, is going to cite this case, this case, this case. So what you want to do is head them off the pass, take what you think they're going to cite, and counter-cite, right? And so make an argument to the judge that these are all the precedents that have been set. This case is more like this than it is like this, so you need to find this, right? And so what you're doing then is you're taking all these precedents, and as a body, all these precedents then are common law or case law, the interpretation of statutory law and applying it to individual cases. And that creates common law or case law. Now, here's the gig. This idea of stare decisis is Latin, and you can roughly translate it to let it stand or let it be. Don't change it. It's a self-imposed judicial principle to let the prior decision stand if at all possible. In other words, it's a self-imposed discipline on the judiciary. It doesn't prevent overturning prior cases, but it puts a heavy burden on the party seeking to have the precedent overturned. In other words, a judge isn't going to willy-nilly or lightly overturn that first case that said Farmer B didn't steal Farmer A's sheep. It's going to take a real a very significant argument for the judge to overturn legal precedent. Legal precedent is a body, as part of the case law or the common law, is going to have far-reaching implications. It's going to be far-reaching in the breadth of its impact. Every time a judge's gavel hits the block, it's setting precedent. It's creating part of that common law. Then this idea of stare decisis, this self-imposed legal principle of restraint, is one of the elements in examining pluralism in its relationship to the judiciary, which is our seminar question. If you think about it just for a minute, every case that's gone before a judge has elements of pluralism in it. You have two parties or more, contesting parties, making their case, looking for an adjudication, looking for the truth. And so if you imagine that one case, and all the lawyers and all the perhaps the jurists that were involved, and all the legal briefs and all the research that went into it, and all the conversation that went into it, right? Especially if you're talking about civil law, this is going to become very important. That conversation in and of itself is a search for the truth in our society. Now you extrapolate that against the tens, dear God, hundreds of thousands of court cases that have happened in this country from 1788 on. And you begin to get a sense of the magnitude of pluralism that's extant, that is evidence that's manifest by that common law, that case law. And so if a judge, by his own self-imposed restriction, says that he's not going to overturn the conversation that happened before, he is respecting pluralism. He's respecting the pluralism that is evidenced in that body of law. Now, if he overturns it, that means that the arguments made today were much stronger than that self-imposed restraint, much stronger than respecting the pluralism that went on, which means to say that it's even more pluralistic, right? Because you're taking into account that this conversation is to be respected, and yet it can still be furthered if necessary. Good, excellent, okay. There's civil law and there's criminal law. And so first we look at civil law, and this may sound familiar to you. Now, I'm not a lawyer. I don't pretend to be, so I'm just going to do a very broad arm sweep introduction to some of these terms. I really encourage you, if you're interested, or if you see this as a field that you'd like to get into, please do some more research. But what I'm looking at is really the search for truth and pluralism in our society. So subjects of civil law are private persons. There is a plaintiff, or somebody who is standing to sue, and a defendant, or somebody who's getting sued, right? And the objects of civil law include torts. So a tort occurs when one deliberately or carelessly causes harm or loss to another person or property. There's contracts, and a contract is basically an agreement between two or more people which creates an obligation to do or to not do something. A contract between two or more people. Probate is the idea that property transfers from the estate of a person who has died, but also it will include, probate courts will include family matters such as divorce, child custody, etc. And then finally you have juvenile courts, which often fall under civil courts because juvenile offenses are a particular, very delicate, very fraught element of law. And so going through the criminal court system isn't always the best for a juvenile. So there are civil judgments that would include money damages, or money judgments, orders to do something or orders not to do something. So the result of a civil case would be, first, money damages. So you're not going to go to jail in a civil case. You go to jail for criminal cases. Civil cases, the finding will be for money damages or orders to do or not do something. Criminal law, there are three basic levels, and depending on the state you're in, the different levels will apply to different crimes, because criminal law is most often state law. And so the penalties for breaking the state law are up to the state, right? With some federal requirements on capital crimes. But for the most part, you have infractions, misdemeanors, and felonies. And so an infraction is a violation of a rule or law that is not punishable by incarceration. You're jaywalking. You throw a gum wrapper on the sidewalk, right? These are infractions. You're not going to go to jail for jaywalking, right? You may get fined, okay? You may have to do community service, but you're not going to get jailed. That's an infraction. A misdemeanor is the next level of seriousness. A minor crime, less than a felony, that is usually punished with a fine or confinement in something other than a prison. So if you have the possibility of going to prison or going to jail, right? If you are driving over 100 miles an hour, if you strike somebody, right? There may be mitigating circumstances, surely, but if you have the potential to go to jail for whatever it is that you're doing, then that is a misdemeanor. Even if they only apply a fine, if one of the potential punishments is to go to jail, then it's a misdemeanor. a felony. Now, this is important, right? Because with a felony, as you know, you lose your right to vote. And a felony is going to follow you the rest of your life. If you ever fill out a job application, have you ever been convicted of a felony? This is going to follow you the rest of your life. So this is an important distinction. So a felony then is a serious crime, like murder, that is punishable by more than 1 year of imprisonment up to death by execution. So now you're talking about imprisonment. You're talking about state prison, not just county jail or city jail. A felony is something for which you can go to prison. So you see these distinctions. So having introduced those elements, now please let me introduce you to judicial theory, or the idea that the courts have the ability to find acts of Congress, the president, or the states, municipalities, unconstitutional. As I suggested back in Chapter 2, the idea of judicial review is in and of itself not in the Constitution. It developed, it evolved. It's a structural element of the Constitution based on institutional elements. We have a court, and we have the ability of the courts to adjudicate. We have the Constitution bearing the Supremacy Clause, which means that anything that is against the idea of the Constitution must fall. Who gets to determine that? The judiciary. Because it's the judiciary who's looking at law and determining it's right or wrong. And so, by very nature then, the courts have the authority for judicial review, but it's not named in the Constitution. So this is an important distinction. It's a structural element and not an institutional element. So judicial review is the right of the federal courts to rule on the constitutionality of federal, state, laws, executive acts, and any bureaucratic regulations. It is the chief judicial weapon in the system of checks and balances. So how it evolved was through a series of 5 court cases that I'm going to go over, 2 in detail and 3 I'm going to do a broad arm wave. So this is Marbury versus Madison, Mcculloch versus Maryland, Dred Scott, Plessy versus Ferguson, and the New Deal cases. First, Marbury versus Madison. John Adams is president. Thomas Jefferson, the Anti-Federalists, the Jeffersonian Republicans, just won the election of 1800. So what are you going to do? You're going to pack the courts. You're going to get as many Federalists on the bench as you possibly can. And so John Adams, up until the last days of his administration, are going to be churning out appointments to the federal bench. The Senate, which is also made up of Federalists, is going to be approving these very quickly. But as they're approved, it's the Secretary of State who must create the commission. So if you're made a judge, you actually have to have a commission. You have to be commissioned by the President with the advice and consent of the Senate to be a judge. I know this sounds like bureaucracy, but there's an element in this because what you're doing is you're processing through the constitutionally required advice and consent procedures to actually be created a judge, to be given a commission to be created a judge. And so there's a legal process that you need to go through, constitutionally defined process. So at the end then, there were 16 commissions that were left outstanding. 16 commissions that hadn't been completed by the Secretary of State. Marbury was one of the 8 commissions that hadn't been delivered. The Adams administration had done all they could to make sure that the processes were correct. Nevertheless, they hadn't been delivered. Madison is the new Secretary of State under Jefferson. Madison, then, is tasked with delivering those commissions. These are Federalists. He's an anti-Federalist. They haven't been delivered. Not my problem. You didn't get it done. Not my problem. It wasn't affected by the end of your tenure. Not my problem. It's not done. They're not justices. They're not official. So Marbury, one of these 8 judges, sues Madison to force him to deliver his commission. He cites the Judiciary Act that says Congress allows to the courts the right to a writ of mandamus against the federal executive administration. Congress says, the Supreme Court has its rights and responsibilities in the Constitution. We're going to add to that, and we're going to say that the Supreme Court also has the authority to order the president to do something. And so it's based on that Judiciary Act that Mcculloch sues Madison, forcing Madison to deliver his commission. John Marshall is now Chief Justice of the Supreme Court. He was a Federalist appointment, and he's between a rock and a hard place. He has one of two choices. He can either refuse to take the case, because the Supreme Court doesn't have to take every case, and if not taking the case, he's going to be seen as knees-knocking in fear of the Jefferson administration. Here you have somebody suing the Jefferson administration based on the Judiciary Act to make them do something.
Andrew Jackson,
Famous for having said, Chief Justice Marshall has made his opinion, now let him enforce it. Remember, the courts at this time don't have any martial authority. They don't have any guns. They don't have any way of forcing their will. All they have is an opinion, right? So Chief Justice John Marshall has made his opinion, now let him enforce it. If he didn't take the case, it would be seen as knocking in fear to the Jefferson administration. Worse, he could take the case, fine for Marbury, order the Jefferson administration, James Madison, to deliver the commission, and have Jefferson ignore him. Even worse, right? So you can see the rock and the hard place that this guy is between. So instead he goes back to the Judiciary Act, the basis, the foundation that this court case is based on, and says, Article 3 creates the Supreme Court, and our jurisdiction, our authority, is limited to the Constitution. You can't give me more power than is in the Constitution because you don't have that authority. You don't have the authority to change the Constitution without going through the amendment process. You can't give me more power, this Judiciary Act, than the founders intended. That in and of itself is unconstitutional. So he took the case and then he rejected it based on the unconstitutionality of the core argument, which was the Judiciary Act. Brilliant. But what you've done then is you've set the precedent for judicial review, that the court has the ability to find, in this instance, an act of Congress unconstitutional. Our next case is Mcculloch versus Maryland. And so Mcculloch versus Maryland deals with the idea of a bank of the United States. Now, this is a big thorn in Jeffersonian Republicans' side. The Anti-Federalists felt that the Hamiltonian plan, because Hamilton was Secretary of the Treasury under Washington, that the Hamiltonian plan to create a national bank was unconstitutional. That the authority to create a national bank was a stretch beyond the Constitution, that the presidency didn't have that authority, the Congress didn't have that authority.
The Jeffersonians wanted to impose a tax on the Bank of the United States, but James William Mcculloch, who was the head of the Baltimore branch of the Second Bank of the United States, refused to pay that tax. The bank was represented by Daniel Webster. The lawsuit was filed by John James, an informer who sought to collect half the fine as provided for by the statute. The case was appealed to the Maryland Court of Appeals, where the state of Maryland argued that the Constitution is silent on the subject of banks. It was Maryland's contention that without specific constitutional authorization for the federal government to create a bank, any such creation would be rendered unconstitutional.
And so it's actually a suit of a citizen against a state, or this state that's allowing this national bank to exist within its borders. And so the question is then, does the federal government have the authority to establish a national bank? And so this is an instance then where the courts are saying, yes, you can, that your act is constitutional, and here's how. Chief Justice John Marshall again said, although among the enumerated powers of government, we do not find the word bank or incorporation, we find the great powers to lay and collect taxes, to borrow money, to regulate commerce, to declare and conduct a war, and to raise and support armies and navies. But it may with great reason be contended that a government entrusted with such ample powers must also be entrusted with ample means for their execution. The power given, it is in the interest of the nation to facilitate its execution. So you're giving Congress all these enumerated powers to raise and support an army and a navy, build post offices and post roads, create all this infrastructure, these huge powers, these enumerated powers in the Constitution. You're going to need to have some kind of a bank, some kind of an institution to run all this business through. You're going to be raising revenues, you're going to be raising tariffs and levying taxes. Are you going to do this out of a roll-top desk? You need a bank, you need an institution.
So we can't go over this too quickly because this is one of the most important Supreme Court cases setting up the precedent of judicial review, which is endemic to our seminar question, and I want to make sure that we do it justice. Marshall's opinion for a unanimous court in Mcculloch read much like an essay in the Federalist Papers. Almost 2 decades into his tenure as Chief Justice, he wrote at the peak of his judicial power and clearly savored his role as chief arbiter of the Constitution. Marshall barely mentioned the National Bank, but he wrote expansively of the congressional powers. His lengthy opinion, issued just 2 weeks after Daniel Webster had concluded his argument, posed and answered 2 questions. Did Congress possess the power to charter a national bank? If it did, could a state impose a tax on its operations? As he often did, Marshall began his opinion with a truism. The government is acknowledged by all to be one of enumerated powers, he wrote. He then made a concession, as he did in many of his opinions. Among the enumerated powers, we do not find that of establishing a bank. But this was a tactical concession. Requiring the Constitution to list all the powers granted to Congress, Marshall continued, would partake of a proximity of legal code and could scarcely be embraced by the human mind. The nature of a Constitution required only that its great outlines should be marked in its provisions and its important objects designated for congressional action. Such minor ingredients of legislative policy as chartering a national bank could be deduced from the great powers entrusted to Congress by the Constitution, or so he reasoned. Marshall deduced, then, that the power to charter a national bank from the enumerated powers of collecting taxes, borrowing money, regulating commerce, and supporting armies and navies. This part of his opinion repeated, almost verbatim, Daniel Webster's argument to the court. Marshall rarely stated anything original in his important opinions. He simply placed his judicial imprimatur on the arguments of the side he favored. So, before moving to the question of whether Maryland could tax the national bank, Marshall paused to make a magisterial statement. Why, he asked, had the framers not employed any restrictive term that limited the enumerated powers of Congress? In considering this question, he wrote, we must never forget that it is a constitution we are expounding. What, if anything, did Marshall mean by this sentence? Later generations of judges and scholars have treated this pronouncement as if it were the 11th commandment of the Mosaic tablets. In truth, Marshall's statement was not scripture, but a self-evident fact. The framers did not limit the enumerated powers of Congress because they did not intend to limit them. That was the reason for the necessary and proper clause, which Marshall construed to authorize a national bank. He could, of course, have construed the clause to justify any federal law he deemed necessary to promote the general welfare of the United States, a power delegated to Congress by the Constitution. So Marshall put the principle of the necessary and proper clause into words that have been quoted and rarely been subjected to critical analysis. He said, quote, let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consistent with the letter and spirit of the Constitution, are constitutional. Close quote. This statement is not self-evident fact, but contains 6 phrases that beg for interpretation. deciding what is a legitimate end of governmental power, how far the Constitution's scope extends, and what are appropriate means of achieving governmental aims, and how those means are adapted to legitimate ends, and above all, how to match laws with the letter and spirit of the Constitution. These are not simple tasks for judges to perform. It was broad statements like these in his Mcculloch opinion, rather than his analysis of the legal questions in the case, that gave his opinion the patina of authority that it now has acquired.
Nevertheless, Marshall found that Congress does have the authority by the implied powers, so that there is an implied power that goes along with the enumerated powers, that if you have these powers enumerated, it's implied that you have to have the power to carry them off into. Now, Dred Scott deals with this issue of slavery. And I like to bring up Dred Scott as an example of the Supreme Court justices not being above regional, racial, or political opinions. So here's how. Dred Scott was the slave of an army surgeon. And by virtue of the Missouri Compromise, that created some states free and some states slave upon their admission, or in their admission to the Union. Some states were slaves, some states were free. That when Dred Scott was moved with his owner, this army surgeon, from a slave state to a free state, that he was, in fact, free. Because by virtue of being a free state, you don't have slavery. And so if you move, then, once you're in that free state, he is no longer a slave. There is no slavery. Does that make sense? But then the army surgeon moved back to a slave state. And so Dred Scott was, in effect, re-enslaved, which was also not legal. So you have the question then of, should Dred Scott be free? Or is Dred Scott free? Now, the army surgeon actually died, and the case was brought by his wife. It was seen as a test case. In the Dred Scott case, Chief Justice Taney and 4 other justices sided along regional lines and found, well, 2 things. One, that Dred Scott, being a slave, could not be a citizen of the United States, and if not a citizen of the United States, did not have standing to sue in that court. That Dred Scott, to be more bluntly with Taney's opinion, he had no rights a white man was bound to respect, according to those Taney. So that was finding number 1. And you would think that that would be sufficient, but they took it a step further. And the Missouri Compromise, the law upon which this entire case was founded, was, now this is a problem that I have, was found to be unconstitutional. Here they have a point, because if you think about it, just very briefly, the Constitution requires what elements a state must pass in order to be admitted. They have to have a Republican form of government, for example, right? So adding the Missouri Compromise that said you can be a state if you're free is adding a requirement beyond that in the Constitution. So just like the Judiciary Act, it went beyond the powers of Congress as enumerated in the Constitution. Okay, fine. Notwithstanding, as a legal argument, here's what happened. The South took the Supreme Court's decision as a triumph, as a huge triumph, that the question of slavery was over forever, and that it was settled. And the South trumpeted this. This was it. This was the final determination. The North could go to hell, right? The abolitionists can go to hell. Well, there's nothing worse than a gloating winner, right? To coalesce an opposition. There's nothing worse than somebody saying, na, 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 right? And so the Whigs, the disenfranchised Democrats, coalesced into a third party in response to, in many ways, Dred Scott. Anybody want to know what that party was called? The Republicans. So Lincoln was the first Republican Party president, right? That this third party, this Republican Party, was formed as a coalition against the pro-slavery elements in the South that were trumpeting Dred Scott as the end-all. Interesting, right? So in a side note of history, Chief Justice Taney constitutionally administered the oath of office to President Lincoln. Now, that would have been fun to watch, right? But there you have Dred Scott. It brought on the Civil War. And so the Supreme Court, again, if you're looking at the policy-making potential of this court, of this judiciary, it's amazing. Another one, just very quickly, is Plessy versus Ferguson. Now, you may be familiar with Plessy versus Ferguson. This is another one of those cases that were actually created. The idea was that the East Louisiana Railroad Company that had segregated cars was in and of itself unconstitutional. And so it was a planned case where a mixed-race gentleman took a seat in the white car and was forced to reseat himself in the black car. And so they sued. And so it was Plessy versus Ferguson of the East Louisiana Railroad Company. And so the question is then, can government desegregate? Or should government desegregate? That's what's at question here. And so Plessy versus Ferguson is going to set up the idea of separate but equal facilities. Something that's going to haunt us from 1896 until basically 1954 with Brown versus Board of Education. So I give you then these two elements, the majority opinion, or a snip of the majority opinion and a snip of the minority opinion. So these ideas are covered in your book. The majority opinion, the majority of the justices of the court writing why they found X, Y, or Z, and the minority opinion arguing their side. Okay. So in Plessy versus Ferguson, the majority opinion, calling out that we can have separate but equal, said, we consider the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the Act, but solely because the colored race chooses to put that construction on it. The argument also assumes that social prejudice may be overcome by legislation, and that equal rights cannot be secured except by an enforced commingling of the two races. If the civil and political rights of both races be equal, one cannot be inferior to the other civilly or politically. If one race be inferior to the other socially, the Constitution of the United States cannot put them on the same plane. So that's the majority opinion. That's allowing for separate but equal. In his powerful dissent, though, now this is what's interesting, because a dissent is often the seed, the germinus for future cases. And so this is John Marshall Harlan, who wrote, I am of the opinion that the state of Louisiana is inconsistent with the personal liberties of citizens, white and black, in that state, and hostile to both the spirit and the letter of the Constitution. If laws of like character should be enacted in the several states of the Union, the effect would be in the highest degree mischievous. Slavery as an institution tolerated by law would, it is true, have disappeared from our country, but there would remain a power in the states by sinister legislation to interfere with the blessings of freedom, to regulate civil rights common to all citizens upon the basis of race, and to place in a condition of legal inferiority a large body of American citizens now constituting a part of the political community called the people of the United States, for whom and by whom, through representatives, our government is administered. Such a system is inconsistent with the guarantee given by the Constitution to each state of a republican form of government, and may be stricken down by congressional action or by the courts in the discharge of their solemn duty to maintain the supreme law of the land. Anything in the Constitution or the state or the laws of the state to the contrary, notwithstanding.
And so, just as with Mcculloch versus Maryland, I really don't want to give too much short shrift to this very important court case, and specifically Justice Harlan's dissent. It really is foundational. As I'm going to suggest, the combination of Dred Scott that found Dred Scott not being a person but being chattel, being owned, then Plessy versus Ferguson, which put the okay on separate but equal, which effectively allowed Jim Crow laws and put a nail in the coffin of Reconstruction following the Civil War, is really important for our understanding of the role of the court in a pluralist society, which is what our seminar question is truly after. So, a major thrust of Harlan's dissent was that the man who wrote the majority opinion, Justice Brown, had erred in distinguishing between political and social rights, limiting the former to jury duty and removing the latter from constitutional protection. Harlan used the broader term of civil rights to include protection from discrimination in all places subject to state regulation, reaching back almost 5 decades in citing a Supreme Court ruling that a railroad company held a sort of public office and has public duties to perform, which must be done without discrimination. But Harlan didn't rest his dissent on precedent. He cited just 10 cases against more than 40 in Brown's opinion. He relied on one simple point. The Civil War amendments, 13, 14, and 15, were designed to prohibit states from discriminating against blacks in their enjoyment of the civil rights that all citizens held. Borrowing from another brief, Harlan put this point into a sentence that has become famous, perhaps the most quoted in Supreme Court history. Quote, "Our Constitution is colorblind and neither knows nor tolerates classes among citizens." Close quote. Harlan's next sentence, borrowed from his own words from a Gibson opinion, quote, "In respect of civil rights, all citizens are equal before the law." Close quote. So the notion of a colorblind constitution has enormous appeal as a guiding principle, but there are dangers in substituting slogans for hard, realistic analysis. Harlan's famous sentence has been ripped from its context by those, including other Supreme Court justices, who have wielded it in recent years as a weapon against affirmative action and other, quote, race conscious, close quote, remedial laws and programs. Those who quote the colorblind sentence invariably fail to quote the sentences that preceded it in Harlan's opinion. Quote, "The white race deems itself to be the dominant race in this country. And so it is, in prestige, in achievements, in education, in wealth, and in power. So I doubt not it will continue to be for all time if it remains true to its great heritage and holds fast to the principles of constitutional liberty." Close quote. So by ripping that colorblind sentence out of its context, we lose its intent. Harlan stated in these sentences the reality of race in 1896, to put this in historical context. Whites held the reins of power, which they used to whip blacks into submission. Harlan does not discern scorn for acknowledging this reality, however much it has reflected this pride of race that he celebrated in his dissent. He had no more desire for social equality with blacks than Justice Brown, who wrote the majority opinion. He was, after all, a man of his time, the son of slave owners himself, and a man of superior prestige, education, wealth, and power. But he was not a racist like Chief Justice Taney in Dred Scott. Harlan wrote, quote, "In my opinion, the judgment this day rendered will in time prove to be as pernicious as the decision made by this tribunal in the Dred Scott case." Close quote. He was right, but hardly anyone agreed at the time. The court handed down decisions in 52 other cases the day it ruled against Homer Plessy. 3 of those, dealing with the laws of contract, inheritance, and copyright, were reported on the front page of the New York Times. The editors relegated the Plessy decision to a third-page column on railroad news between cases on train routes and improvement bonds. And the court's leading historian, Charles Warren, did not even mention Plessy in his massive work, published 3 decades later.
The next one then, and this is kind of fun, the New Deal cases. So this is Franklin D. Roosevelt, FDR, right? And FDR is elected to the presidency with a great mandate, right? With a huge push in the electorate. So they want FDR, they want the New Deal, they want this being brought out of the Depression, the economic depression. And so a good part of the New Deal legislation were individual pieces of legislation that created, they called it the alphabet soup, the Works Progress Administration, the Civilian Conservation Corps, right? These programs that were intended to help prime the Keynesian pump, the economic pump, check? Not surprisingly, what the New Deal legislation does is it creates a vast bureaucracy under the president. What you're doing is you're creating a bureaucracy in order to create jobs, right? To get money back into the economy by creating these jobs. It's not surprising that the Supreme Court then found this expansion of presidential power unconstitutional. Now, the court is by nature non-political and unresponsive to public opinion. Their job is to interpret the Constitution. Obviously, I'm playing both sides here. So there were what they called the four horsemen of reaction, who almost as a knee-jerk response, voted against all these New Deal legislations coming through. People would sue, they would claim harm, it would rise to the Supreme Court, and the four horsemen of reaction, one by one, would strike down these pieces of legislation. Now, here comes the fun part. You ready? Nowhere in the Constitution does it say there are 9 justices on the Supreme Court. There is no limit, either a minimum or a maximum. It just says that the president appoints and the Senate confirms.
Now, Congress has put forward legislation that sets the limit of the number of the court, but because that's legislation, it can easily be reversed as opposed to a constitutional requirement that would need a constitutional amendment to strip.
There's been as few as 6. I think it's been as many as 11 at one point, but it's traditionally been 9. But there's nothing constitutional, again, that says it's 9. So FDR said, these four horsemen of reaction have been working so hard that I'm going to appoint another associate justice for every justice over 70 that's already on the bench in order to assist you, to lighten your work. You get the idea, to lighten your workload, right? And so since they were all over 70, what we're doing is we're talking about doubling the court from 9 to 18. And so all FDR had to do was hint at this. Historians ponder, could he have done it? Right? Would the Senate have gone along with it? Right? Were we in such dire straits that they would have allowed doubling the Supreme Court? Because they had to set aside the opinion of the power of these 4 justices in stopping the New Deal legislation going on. It was enough for him to threaten, apparently, because they started backing down and they started allowing the pieces of legislation to go through. Interesting. So justices aren't above personal ego, because what would happen is their voice would have been watered down by half.
The Constitution is almost completely silent concerning the organization of the federal judiciary. That there should be a national judiciary was readily accepted by all, but whether it was to consist of one high court at the apex of a federal judicial system, or a high court exercising appellate jurisdiction over state courts, which would initially hear all but a minor fraction of cases raising national issues, was a matter of considerable controversy. The Virginia plan that we talked about in Chapter 2 provided for a national judiciary to be established to consist of one or more supreme tribunals and of inferior tribunals to be chosen by the national legislature. In the Committee of the Whole that we discussed, the proposition that a national judiciary be established was unanimously adopted, but the clause to consist of one supreme tribunal and of one or more inferior tribunals was first agreed to, then reconsidered, and the provision for inferior tribunals stricken out, it being argued that the state courts could adequately adjudicate all necessary matters, while the Supreme Tribunal would protect the national interest and assure uniformity. Wilson and Madison thereupon moved to authorize Congress to appoint inferior tribunals, which carried the implication that Congress could, in its discretion, either designate the state courts to hear federal cases or create federal courts. The word appoint was adopted, and over the course of the convention changed into phrasing which seems to impose an obligation on Congress to establish inferior federal courts. As I mentioned earlier, the Good Behavior Clause excited no controversy, while the only substantial dispute with regard to denying Congress the power to intimidate judges through actual or threatened reduction of salaries, well, that came on Madison's motion to bar increases as well as decreases.
Let's look at the structure of the courts, just very quickly. You have the Supreme Court, the Court of Appeals, the district courts, the military courts, and the international trade courts. So, as we know, the Supreme Court is created by the third article in the Constitution, Article 3. And so then the U.S. Supreme Court is established by the Constitution, but all courts inferior are created by Congress. So the Court of Appeals, the district courts, these are all created by Congress. And if they're created by Congress, then Congress gets to determine their jurisdiction, their authority, the qualifications for the judges, their salary, right? All the other elements, when you create a court, you get to call all those shots. The only court created in the Constitution is the Supreme Court specifically. So then the Court of Appeals, which is the next step down, wasn't created actually until 1891. It's relatively recent. And they serve as gatekeepers to the Supreme Court. So originally you had the district courts, and I'll talk about this in a second, and then the next level of appeal would be the Supreme Court itself. Well, that's a pretty big jump. That's too much of a workload, especially as the power of the judiciary expanded. So the district courts then, findings would be appealed to now the Court of Appeals, and then the Supreme Court would hear appeals from the Court of Appeals, or would be the next step up from the Court of Appeals. So what you're doing is you're applying a filter between the district courts and the Supreme Court. And so you have the Court of Appeals, and they have only appellate jurisdiction. In other words, they don't have original jurisdiction. They don't hear original cases. All they're hearing are appeals from the district courts, and what they're hearing is, were all the constitutional protections of due process applied in that case? Were all the appropriate mechanisms in place to protect the defendant? Were they given their due process? That's what the Court of Appeals is asking. They're not hearing new evidence. They're not retrying the case. They're looking at how the case was affected in the lower court and if it was done constitutionally. They also hear appeals from the decisions of several federal regulatory agencies, such as the ICC, the Nuclear Regulations Commissions, and the FTC. There was an interesting case. Remember when we were doing the presidency, I talked about the bureaucracies having quasi-legislative, quasi-executive, and quasi-judicial powers. So the Federal Elections Commission passed a policy, or invoked a policy, whereby the Tea Party organizations were applying for protection from being forced to publish their donor rolls. And so years ago, the Federal Elections Commission had said that in policy, as quasi-legislative, some organizations, some party organizations, need to have their membership rolls protected because their participation in the process is so important that if we force them to publish their membership rolls, we'll put them out of business. Here's how. They were thinking about the Socialist Party and the Communist Party in the 1950s. And so the question is, if we force the Communist Party to reveal its membership, chances are that membership is going to dry up. They're not going to participate because they're not going to want their names put out there, right? We're talking about being hunted down for the most part. So the Federal Elections Commission said, we will allow certain groups to not publish, or will not force them to publish their membership. Then quasi-executive said, and this is going to apply to the Socialist Party, the Communist Party, right? Well, the same regulatory agency, faced with a request from Tea Party organizations for the same exemption, said no. No, because we're talking about the difference between, well, the Socialist Party had like 17 donors. The Tea Party organization in question has upwards of $150 million worth of donations. So we're talking about real money here and real influence. So they said, no, this policy doesn't apply to you. I bring this all up for a reason. What's the next level? The Court of Appeals. They hear appeals from regulatory agencies. So it doesn't stop with the regulatory agency. It actually comes out of that agency and into the judicial system. Because I said any act of Congress, the president, or regulatory agencies are up for review by the courts. No regulatory agency is higher than the Constitution, so you have to be able to have some judicial review, some interpretation of the Constitution vis-a-vis these regulations. So the district courts, there are 632 federal district courts. 80% of the federal cases that come before the federal judges are tried in these federal district courts. Usually cases tried in federal district court are heard by a single federal judge, with the exception of voting rights cases and redistricting cases. So each state has at least one judicial district, kind of like a congressional district, and 2 judges are assigned to each district. U.S. district courts cover an assigned territory based on geographic regions. They have original jurisdiction over most of the cases heard in federal courts. In other words, they're the first court to hear a case. They have original jurisdiction. They hear both civil and criminal cases, and they have both petite and grand juries. You say a grand jury. Now, what the heck is a grand jury? So the framers of our federal Constitution deemed that the grand jury was so important for the administration of justice, they included it, if you remember, in the Bill of Rights. The Fifth Amendment to the United States Constitution provides in part that no person shall be held to answer for a capital or otherwise infamous crime without the action of a grand jury. An infamous crime is a serious crime which may be punished by imprisonment for more than a year, a felony. The purpose of the grand jury is to determine whether there is sufficient evidence to justify a formal accusation against a person. That is, to determine if there's probable cause to believe that a person has committed a crime. If law enforcement officials are not required to submit to an impartial grand jury proof of guilt as to a proposed charge against a person suspected of having committed a serious crime like this, then they would be free to arrest a suspect and bring that suspect to trial, no matter how little evidence existed to support the case or the charge. So here's the idea. You have a group of people. Now, you know the trial jury, right? The idea of a trial jury, 12 persons on a criminal case, 9 persons usually on a civil case, who hear the case and adjudicate, right? A jury of your peers. The same is true going into the system. According to the Bill of Rights, then, before you can be charged with an infamous crime or a felony, a grand jury, a jury of your peers, needs to sit down and go over the evidence to make sure that there's enough evidence to seriously charge you with a crime. Because if you're charged with a crime, that's going to change your life. Even if you're found innocent, it's going to mess up your life, right? You're going to be dragged through the mud. You're going to have to defend yourself also. So how can we stop the potential abuse of this, even this accusatory process, then having a grand jury or some kind of a filter between the martial authority, the law enforcement authority, and the individual? Again, it's all about protection of liberty and individual right. There are other courts in the system, and these include a United States Claims Court. So the United States can't be sued by anyone in any court for any reason without its consent. So the United States has to agree to be sued. And this happens then in the United States Claims Courts, or claims against the United States. So it hears cases from all over the country in which there are claims for damages against the federal government. Originally, before 1855, a person with a claim against the United States could secure redress only by an act of Congress, which is the First Amendment. Territorial courts are another type of court. Congress created the courts for the nation's territories. So at this time, there are 3 courts: the Virgin Islands, Guam, and the Northern Marianas. And these courts operate much like local or state trial courts because we're talking about federal territories then. They're federal courts and they're created by Congress. There's the courts of the District of Columbia. The District of Columbia has its own system of courts. Because it's not a state, it doesn't fall into that system. The system, again, was established by Congress. There's the Court of Military Appeals. So the 3 judges of this court are civilians appointed to 15-year terms with the consent of the Senate. And so this court, sometimes called the GI Supreme Court, hears appeals from serious court-martial convictions. Its decisions may be, but almost are never appealed to the United States Supreme Court. So the Court of Military Appeals, the Court of Veterans Appeals. So these 7 justices are appointed by the President for 15-year terms, again with the consent of the Senate. They hear appeals from veterans who claim that the Veterans Administration has mishandled their case. And appeals from the Court of Veterans Appeals go to the Court of Appeals for the federal court. The United States Tax Court. So if you don't pay your tax bill, this is where you don't want to go. The 19 judges of the tax court are appointed by the President for 12-year terms. It was first established in 1969. They hear only civil cases involving dispute over the application of tax law. The International Trade Court has 9 judges who hear only civil cases arising from the tariff and other trade-related laws. Appeals from the Trade Court go to the Court of Appeals. The Court of Appeals for the Federal Circuit. Now, this is different from the Court of Appeals. The Court of Appeals for the Federal Circuit has 12 judges. It was set up in 1982 to centralize the appeals processes in certain types of federal cases and in cases from certain lower and special courts. So again, they hear appeals from the International Trade Court, the Court of Veterans Appeals, and the Merit System Protection. So next then, we have 2 more elements. One is the route to the Supreme Court and how the Supreme Court runs or how it operates. Then we're going to be looking at voting patterns of the court, the idea of judicial activism. We'll talk about constructionalists versus activists. And then I want to talk about the pluralism in the court, including timelines of appointment. And then we'll get back to our seminar question, which is how does the prerogative of judicial review of the court complement or detract from the ideal of representative democracy and of pluralism? Most federal cases, as I said, begin in the district court. Most are straightforward and do not lead to new public policy. The Supreme Court does hear those cases rising from the district courts and from the Court of Appeals, and it does pick the cases it wants to hear. What it does is it issues a writ of certiorari, in other words, a call from the higher court to the lower court for the records of the case. So it can establish a writ of certiorari to call up records, to demand that those records be brought to it so that it can hear it on appeal at the Supreme Court level. So the Supreme Court rejects over 90% of applications for a writ of certiorari. So an application for a writ of certiorari is somebody who is lost in the Court of Appeals and wants to take it all the way to the Supreme Court. What they do is they apply for the Supreme Court to establish a writ of certiorari. And so the court only takes, as I suggest, it rejects 95% of those applications. The costs of appeals are high, but can be lowered by payments from interest groups. The costs of appeals are high, as I suggest, but can be lowered by payments or participation by the interest groups, such as the American Civil Liberties Union. But each party must pay its own way, except for cases in which it is decided that the losing defendant will pay, which is called fee shifting. There are standing guidelines for a case to get to the Supreme Court. It must be a controversy between adversaries. Personal harm must be demonstrated. So you may remember the contested election between Gore and Bush in 2000. One of the questions that the lawyers kept asking when rising to the level of the Supreme Court is how do we show personal harm? How can we show that George W. Bush would be personally harmed by a recount in the state of Florida? Always that the Supreme Court allows for sovereign immunity. So briefs are submitted to the Supreme Court prior to the court hearing the case. And then oral arguments are made by the lawyers based on their briefs. Each lawyer is given a half hour to present their case, but that half hour is always interrupted by the justices themselves asking questions. And the justices asking their questions doesn't add to your half hour. It's a part of your half hour. And so lawyers are familiar with this idea that the questions and answers going back and forth between the justices are based on the idea that the justices have already read your brief. They know what you're going to say. So it's really more of a question and answer. They're trying to set the tone of the case by asking questions. The Solicitor General of the United States has a role deciding what cases the federal government will appeal from lower courts, and personally approves every case that the government presents to the Supreme Court. So remember, it's the Solicitor General, according to your book, who is going to be representing the United States when the United States is in a legal action. Now, this is different from the Attorney General, who is the head of the Justice Department. And so the Attorney General is the head of the Department of Justice. It's different from the Solicitor General, the person whose job it is to defend the United States in civil case, or forgive me, in court cases. There are conference procedures that are endemic to the Supreme Court, and they're really rather fascinating, and intricacies of the conference procedures within the Supreme Court. For example, that the Chief Justice speaks first and votes last. Imagine if you're in a group, if you're in a conversation, and you're trying to come up with a decision whether to order a cheese or a pepperoni pizza. So if you're the Chief Justice, then you speak first. In other words, you're setting the tone of the case. You're setting the basic arguments of the case. But then you get to vote last. And so in an odd-numbered panel, 9 judges, often pretty closely split, it's usually the Chief Justice who's going to be casting the deciding vote. And so there is, within the court conference procedures, the selection of an opinion writer, both for the majority and the minority. Each individual justice, however, can write their own opinion on a case. They can have an opinion individually on the case, but there is usually a majority and minority opinion. In other words, there are concurring and dissenting opinions. So if you have a majority opinion, you can have a concurring opinion by a justice, perhaps adding to the majority opinion or another element of the majority opinion that they felt wasn't adequately covered, or perhaps they wanted to elaborate on. And on the minority opinion, you have a justice who is able to add to the argument their special consideration or their special thoughts that aren't included in the minority opinion. And so in the voting patterns of the court, I'd like to introduce you to 2 concepts, and these are covered in your book, which are judicial activism and judicial restraint. And so perhaps the most activist court in the history of the U.S. Supreme Court was the Warren Court, 1953 to 1969. And it faced the question of determining the future of the civil rights movement, among other things. So critics of judicial activism believe that Congress and not the court should make policy. So if you look at this, what they consider this activist court, this Warren Court, 1953 to 1969, you're going to see a great deal of examples where the Supreme Court perhaps took on the hard questions that the political branches, the Congress, the President were unwilling to tackle, such as Brown versus Board of Education, the idea of segregation, the idea of civil rights. So oftentimes the political branches are unwilling or unable to address really divisive social issues, and it's often the courts who step in. Now, depending on which side of the fence you're on, if you're looking at if you're looking at a court case from a pro or con, when the court comes down on one side or the other, you might look at it as either activist or restrained. But judicial restraint then, if you look at the Ranquist Court, and this is from 1986 to 2000, was considered the most conservative court in United States history, exercising judicial restraint at every opportunity. So restraining from making broad political decisions or broad policy-making decisions, like Roe v. Wade or Brown versus Board of Education. So the Ranquist Court is very conservative and by nature restrained. And so looking at views of judicial activism, or the idea that courts should step in political arguments or political questions, the supporters of activism suggest that courts should correct injustices when other branches or perhaps state governments refuse to do so. that courts are the last resort. Because they're not accountable to public opinion, they can make those hard decisions without fear of facing re-election or facing the ire of their constituents. Now, we're getting to the idea of pluralism, so please bear with me. Critics of judicial activism say that judges lack political expertise to make those hard opinions, that their job is to interpret the Constitution and not to set policy or to set national policy. It's suggested, too, that the courts are not accountable and they're not elected. The very nature of what makes the supporters think that they're the proper branch to make these hard decisions or should make these hard decisions when the political branches don't are the very criticism that the opponents of judicial activism cite as the reason they shouldn't make those decisions, because they're not accountable to the people, they're not elected, they're not a part of that political process. So the debate is over how the Constitution should be interpreted. And so you have strict constructionalism, whereby judges are bound by the wording of the Constitution. So to hold dear to the wording, the actual wording of the Constitution. Activists feel that there should be a looser interpretation of the underlying principles of the Constitution. So again, privacy is nowhere in there. So a strict constructionalist would say privacy doesn't exist because it's not named in the Constitution. A loose constructionalist would say, yeah, but the Third Amendment, the Fourth Amendment, the Eighth Amendment all allude to the idea of privacy, so we should expect that there is a right to privacy. And so a strict constructionalist or an activist or a loose constructionalist, it's not a matter of liberal versus conservative. Please don't conflate these two ideas. A judge can be both conservative and activist, or liberal and strict constructionalist. Today, most activists tend to be liberal because the political branches tend to shy away from those more progressive policy issues. So it just happens that the liberal activists show up more often than the conservatives or the strict constructionalists, because they're making those hard decisions that the political branches are afraid to. Those are often progressive decisions. Those are often decisions that will further a progressive movement. So we often conflate liberal/progressive with activist judges, because those are the decisions being made, the hard decisions in the courts. So if you're looking then for evidence of pluralism in the court, which is the foundation of our seminar question, right? So pluralism in the court, I would argue, begins with the idea of amicus curiae briefs, right? And it's the idea of the friend of the court brief. And so a brief is a written summation of an argument, right? A legal argument. That's often a brief is submitted to the court from the plaintiffs or the defendants, right? So they're laying out their side of the case and their legal research and their list of precedents and citations, etc. But we're talking about pluralism and the idea that there is a broader conversation happening, although the pluralist model, even within the courts. It's not just the plaintiff and the defendant and the judges, maybe the grand jury, who are having this conversation. An amicus curiae brief brings to the attention of the court relevant matter not already brought to its attention by the parties, and may be of considerable help to the court. An amicus curiae brief that does not serve this purpose actually burdens the court, and its filing is not favored, it's not encouraged. So an amicus curiae brief may be filed only by an attorney admitted to the practice before the court. So what an amicus curiae brief then does is to list from a specific party's viewpoint the pros or cons of an argument in a case. And so, for example, in the DOMA, the Defense of Marriage Act, and Proposition 8, there were over 78 amicus curiae briefs filed on both sides. In other words, 78 individual concerns, groups, got together to tell the court what they thought from their perspective of a specific issue. So I'm thinking the American Civil Liberties Union, I'm thinking the Traditional Values Coalition, I'm thinking the U.S. Conference of Catholic Bishops, I'm thinking about the Human Rights Campaign. These interest groups that we studied in Chapter 7 are contributing to the conversation in the courts by filing these amicus curiae briefs. Court packing can be another element of pluralism if you choose to look at it this way. So court packing is the idea of a political branch, the executive, in collusion with the Senate, because the president appoints, the Senate confirms, right? So those two packing the courts with loyal Federalists, a la John Adams, right? Or George W. Bush, or Barack Obama.
Or Donald Trump with Mitch McConnell's support. Please don't let the media fool you. This is a tactic that's as old as the hills and goes back to John Adams and Marbury v. Madison, remember?
The Senate debating whether to do away with filibuster on judicial appointments. So one of the problems with judicial appointments is that they're often politically charged. And in the Senate, when you're reviewing a presidential appointment, you can use it as a political opportunity to either help or hinder that president fill the bench, right? And so the Senate then can either help collude with the president to pack the court, to get a lot of strong Democrats or strong Republicans or progressives, conservatives on the court, or not. So what does this do to pluralism, both pro and con, this idea of court packing, or getting political advantage in appointing people to the bench? Well, if you think about it for a minute, you're talking about the path to the Supreme Court. How does a case get to the Supreme Court for the court to find acts of Congress, the president, the states unconstitutional as a final arbiter? But through the lower courts. And so if the district courts and the Court of Appeals are heavily progressive or heavily conservative, then the path to the Supreme Court for years is going to be affected by your appointments today. So let's say George W. Bush, who served 2 terms, right? 8 years, had a strong advantage in packing the court by virtue of the length of his tenure, the length of his administration. So for 8 years, George W. Bush was able to get his appointees, right, into the lower courts, into the Court of Appeals, into the district courts. Why would the Senate, who was Democrat, drag their feet mightily to stop these things from happening? Because for every judge that's appointed for life on the district and Court of Appeals, they're going to have a long, long echo of either conservative or progressive mindfulness in their findings. And so the path to the Supreme Court is going to be changed for 20, 30 years into the future by virtue of what's going on today, what appointment is being made today. So court packing has a pro and con aspect to pluralism, or an effect on pluralism. I encourage you for a minute to think about the iron triangle. Now, we talked about this in Chapter 12. This is the unbreakable relationship between interest groups, congressional committees and subcommittees, and bureaucracies. So think about the appointment process, just the appointment process in court packing for a minute. So who's in on the conversation? Well, you have the Department of Justice in the voice of the Attorney General. The Attorney General is going to be in every conversation in the White House about who to appoint to the district, Court of Appeals, or even the Supreme Court. The President is going to seek advice from the Attorney General. He is the head of the Department of Justice. He is going to be an integral part, an integral player in the nomination process, right? Especially with the lower court judges. The Supreme Court is so political, it's so highly charged that you have a list now of potential Supreme Court justices who are being vetted for appointment 5, 10 years into the future. But think about the lower courts. There's a lot of changeover. You have 600 plus district courts. You have a lot of potential for turnover. So the Attorney General and the Department of Justice is very active. He's very engaged in the selection of judges for the lower courts. So that's the bureaucracy, right? Department of Justice. So then you have the Congress in the Judiciary Department in the Senate specifically. So the Judiciary Committee, in the Senate is going to be the one who's going to be approving the president's appointments, suggested by the Attorney General. Now, what interest groups are there? Oh my God, you can't swing a cat without hitting an interest group in this conversation. Because who are they going to be lobbying? The President, the Attorney General, and the Congress, the Senate, right, from their vantage point. The American Catholic bishops, the ACLU, the Human Rights Campaign, they're all going to be lobbying the President, the Attorney General, and the Congress for their favored justice. Okay? But then really, let's talk about pluralism. So this is my favorite exercise. Are you guys ready? Okay, good. Now, you saw me putting up a bunch of dates while we were on the break, but I want to introduce you to the faces. So this is today's Supreme Court. You have when were they appointed and by whom, and how does their appointment process give evidence of pluralism? So the argument against the court is that they're non-political, that they're not elected by the people, right? And so by not being elected by the people, they're not accountable to the people, and so they're like this removed, they're seated for life, they're removed, they're inured, they're filtered. There's 9 justices, so 5, a simple majority. So 5 people can change the outcome of a decision that will affect millions of, I'm thinking about DOMA, I'm thinking about same-sex marriage, Prop 8. So 5 justices made a decision that changed the course of history. 5 individuals, 5 people changed the course of history. Check? Now, albeit you can have a constitutional amendment, I'm not saying that that process isn't true. There's always another step, but for the most part. So the question is, who are these people? Now, and how do we give evidence of pluralism?
So it would be at this point that I would ask you to maybe pause the video and go out online really quickly, maybe Google, and look at the current panel of Supreme Court justices. Looking at the longest serving to the most recent serving, imagine what it takes to become a Supreme Court justice, right? We have the president who appoints and then the Senate confirms. We've recently watched a number of very divisive confirmation hearings wherein pluralism, the voices of the minority and the majority and the interest groups and the committees and, oh my gosh, everybody was talking about these candidates for the bench. Well, imagining then that that happens 9 times. So for each Supreme Court justice that's been seated, imagine that the president who appointed them had to go themselves through a vetting process by being elected to national office. Imagine then, too, the Senate that needed to be elected to confirm those appointments. Now, we know that the Senate is created by thirds, 1/3, 1/3, 1/3. And so you're looking at 3 elections over a 6-year period. So I would imagine that looking at the longest serving Supreme Court justice to the newest serving, you have 9 individual instances then of very vast and broad pluralistic exercises between the election of the president, the election of the senators, the appointment of the justices, and their confirmation hearings. The pluralism inherent in the timeline of appointment is vast when you look at the numbers of people voting. Looking at the current panel, I'm reminded that my mom and my dad, who went off to their reward many years ago, voted for a president who appointed a sitting Supreme Court justice. So their voices, although they've been off the planet for quite a while, are still echoing through with that president's appointment of those justices. So I would argue that just in the selection process and the vetting process of Supreme Court justices adds to the pluralism inherent in the judiciary.
Going back to our seminar question, does the prerogative of judicial review held by the Supreme Court complement or detract from the ideal of representative democracy? So what is the ideal of representative democracy? We know that direct democracy is fraught, right? You're talking about Hamilton and the mass public. You know, people are misinformed, apathetic, and not to be trusted with the reins of power. We're not talking about direct democracy. We're talking about representative democracy. Or the people come together and through a filter, Congress through the legislative process, through the legislatures, and the president through the electoral college. But now in the Supreme Court through the appointment confirmation process. How does the prerogative of judicial review, with an eye to the appointment confirmation process, complement or detract from the ideal of representative democracy? The ideal being the best of both, that the people have a voice, but not too much voice, that the people are participatory, but they don't make law directly. Right? Even with the presidency, they're not directly electing the president, it's done through a filter. And then of pluralism. And so the prerogative of judicial review and pluralism. So the more voices, the better. If you pick a piece of legislation, pick Roe v. Wade, Brown versus Board of Education, DOMA, I don't care. Pick a case, right? And tear it apart and say, okay, what is pluralism? What was the pluralism involved? The more voices, the better. Think Iron Triangle. Think amicus curiae briefs. Think Starry Decisis. All these elements begin to come together. And so what you can do then is you can create the seminar questions outline simply by creating a good thesis statement. The prerogative of judicial review held by the Supreme Court complements and detracts from the ideal of representative and of democracy. So paragraph number 1. You guys, this is so old hat to you by now. Paragraph number 2. What is the prerogative of judicial review? Describe what that is, right? Paragraph 3. What is the ideal of representative democracy? Paragraph 4. Remember, your reader knows nothing. What is pluralism? So that's paragraph 4. Paragraph 5. How does it add to? Paragraph 6. How does it detract from representative ideal? 8, 9. Adds to or detracts from pluralism. 10. Conclude.
And that brings us to the close of our lecture today on the judiciary, the courts, the judicial system. Again, as always, I thank you for your attention and for your patience. I look forward to reading your essays, the 2.5 to 3 page essays that are due on the date outlined in your class platform. Again, this is Mike Corrali with the Introduction to United States Government class online. Thank you.